Hello friends, how are you all? I hope you all would be fine and striving for your bright future. In this video, we'll study 50 MCQs based on subject Public International Law. I think these MCQs shall be helpful in your learning. So please stay tuned with me till the end of video. So let's get started. Question number 1. Who among the following is known as father of international law? Grotius, Austin, Bentham, Pluto. Grotius is right answer. Question number 2. Who used the word international law for the first time? Option A, Hall. Option B, Hobbes. Option C, Oppenheim. Option D, Jeremy Bentham. D is right, Jeremy Bentham. Question number 3. Who said international law is vanishing point of jurisprudence? Austin, Holland, Oppenheim, Stark. Holland is right. Question number 4. Who said international law is a weak law? Bentham, Hall, Grotius, Stark. D is right, Stark. Question number 5. Who said international law is not a law but only positive morality? Austin, Holland, Oppenheim, Stark. Option A is right. Question number 6. Common consent of family of nations is the basis of international law. Was said by Austin, Holland, Oppenheim, Stark. Option C is right, Oppenheim. Question number 7. International law is real law. Was said by Austin, Holland, Oppenheim, Stark. Option D is right, Stark. Question number 8. De jure belle ac pacis 1625, an epic on international law, is written by option A Grotius, option B Austin, option C Bentham, D none of the above. Option A is right, Grotius. Question number 9. International law has no legislation, executive and judiciary authorities, that is lacks command, duty and sanctions in true sense. Was said by Austin, Hall, Hart, Stark. A is right, Austin. Which of the following is a sanction in international law? Sanctions by states, collective sanctions by international organizations, public opinion, D all of the above. D is right, all of the above. Question number 11. Who of Question number 11 is law of nations or international law is the name for the body of customary and conventional rules which are considered legally binding by civilized state in their intercourse with each others. Is the definition given by option A Kelsen, option B Hall, option C Oppenheim, option D Stark. C is right, Oppenheim. Question number 12. A subject of international law is human being upon which the rule conference. Option A right and capacity and imposes duty and responsibility. Right and capacity only, right and duties only, none of the above. Option A is right. Question number 13. Who are the subjects of international law? States only, international organizations, individuals, all of the above. D is right, all of the above. Who said that there is only one source of international law, viz. Common consent? Oppenheim, Stark, Grotius, Bentham. Option A is right, Oppenheim. Option A is right. Question number 15. The main source of international law in Article 38, Clause 1 of the Statute of International Court of Justice is Inter- International Convention and Customs, General Principles of Law recognized by civilized nations, judicial decisions and teachings, all of the above. A is right. International Convention and Customs. Question number 16. In Article 38, Clause 2 of ICJ, the words ex equo et bono means consideration of fair dealing and good faith, bona fide behavior by state, relationship of past does not bother present, none of the above. A is right. 17. Which is the oldest and original source of international law? International treaties and conventions, international customs, general principles of law recognized by civilized nations, all of the above. B is right. International customs. Question number 18. Custom and uses are antonyms, synonyms. Uses is first step towards custom. Custom is first step towards uses. Option C is right. Uses is first step towards custom. Question number 19. Uses represents the twilight stage of the customs. Custom begins where uses end, and uses is an international habit that has yet not received full length attestations, said by Oppenheim, Stark, Brierley, Holland. Option A is right. Oppenheim. Question number 20. Custom includes the following features. Option A consistency, continuity, and uniformity. Option B antiquity. Option C efficacy and consistency. Option D both A and B. D is right, both A and B. Judicial decision and juristic work are a primary and important source of international law, a subsidiary and indirect source of international law, a direct source of law, a modern source of law. Which is right answer? B is right, a subsidiary and indirect source of international law. Question number 22. As to recognition of state, which convention has said the state should possess four qualifications: permanent population, definite territory, government, and capacity to enter into relations with other states? Option A Vienna Convention 1996. Option B Montevideo Convention 1993. Option C Genocide Convention. D none of the above. B is right. Montevideo Convention 1993. Who said recognition is a political diplomatic function, not absolutely legal? Option A Oppenheim, Stark, Hegel, Philip Jessup. D is right, Philip Jessup. 24. A state is and becomes an international person through recognition only and exclusively. This is the viewpoint of which theory? Constitutive theory, declaratory theory, facultative theory, none of the above. Constitutive theory. Recognition is merely a formal acknowledgement through which established facts are accepted. This is the viewpoint of which theory? Option A constitutive theory, declaratory theory, facultative theory, and none of the above. Option B is right, declaratory theory. 26. According to which theory recognition depends upon the discretion or sweet will of recognizing state? Constitutive theory, declaratory theory, facultative theory, none of the above. Option B is right. Declaratory theory. 27. Constitutive theory has been advocated by Oppenheim, Hall, Wenger, Berle. A is right. Oppenheim. 28. Declaratory theory, also called evidentiary theory, has been advocated by Hegel, Ancelotti, Oppenheim, Berle. Berle is right. 29. Who said recognition is declaratory of an existing fact but constitutive its nature, at least so far as concerns relation with the recognition state? Oppenheim, Stark, Hall, Wenger. Oppenheim is right. Who said recognition all is declaratory of the existence of the natural statehood? It is constitutive of jurisdictional, sorry, jurid, juridical statehood. Option A, Oppenheim, Stark, Kelson, Hall. Option C is right, Kelson. Question number 31. According to which theory of the recognition is a political or discretionary act? Constitutive theory, declaratory theory, facultative theory, none of the above. C is right, facultative theory. It is the duty of the state to recognize other state. Who said it? Lauterpacht, Stark, Oppenheim, Hall. Option is right, Lauterpacht. Question number 33. When a state enters into a bilateral treaty or establishes diplomatic relations with an unrecognized state, it implies express recognition, implied recognition, conditional recognition, none of the above. B is right, implied recognition. 34. If a state is admitted as a member of the United Nations, it amounts to express recognition, implied recognition, conditional recognition, collective recognition. D is right, collective recognition. Question number 35. Which of the following is final, permanent, irrevocable? Option A, de jure, de facto, precipitate recognition, both A and C. De jure is right. Question number 36. Which of the following recognition is temporary and revocable? Option A, de jure, de facto, precipitate recognition, both A and C. B is right, de facto. When a new state is formed through revolt, recognition unusually granted is de jure, de facto, precipitate recognition, both A and C. Option B is right, de facto. Mark the incorrect statement. De facto recognition state cannot a claim to properties situated in the territory of recognition state. It lacks extraterritorial jurisdiction. De jure recognition state can claim property situated in the territory of recognizing state. There is substantial similarities in legal incident of de facto and de jure recognition. Thus, the recognition state treats the legislative and executive act of a de facto or de jure recognition state as having full length effect. Option D is none of the above. Option D is right, none of the above. So this is very consuming question. The UNO came into existence on 26 October 1946, 25 4th October 1945, 24th October 1948, 25th October 1944. Which one is right answer? B is right, 24th October 1945. The purpose of the United Nations in world peace was the purpose of United Nations is world peace was said by who said it? Stark, Kelsen, Hall, Oppenheim. Option B is right. Kelsen. Which of the following is not an aim object of the United Nations as set forth in the preamble of the United Nations? To save the succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights and in the dignity and worth of the human person. The member states shall to fulfill in good faith their obligations under the Charter, to establish conditions under which justice and respect for international law and international obligations can be maintained. Which is right one? Option C is right. The member states shall to fulfill in good faith their obligation under the Charter. Question number 42. Purpose and principle of United Nations are laid down in Article 2 and 3, Article 3 and 4, Article 1 and 2, Article 1 and 3. C is right, Article 1 and 2. The main purpose of the United Nations is to maintain international peace and security, to strive to bring about friendly relations among nations, to promote social progress, to promote economic and social advancement of all the people. A is right, to maintain international peace and security. Under which article human rights have been mentioned in the United Nations Charter? Article 1 Clause 1, Article 1 Clause 3, Article 1 Clause 4, Article 2. B is right, Article 1 Clause 3. Article 1 Clause 3 of the United Nations Charter seeks international cooperations in solving international problems of economic and social character, cultural, economic and social character, economic and humanitarian characters. Option D, all of the above. D is right, all of the above. Question number 46. The basis of United Nations is sovereign equality, economic and social advancement of the people, both A and B, none of the above. A is right, sovereign equality. Of question number 47. The United Nations cannot in any case lawfully affected non-member state interfere in the matter which are within the domestic jurisdiction of member state. Both A and B correct. Both A and A and B incorrect. Which one is right? B is right. Interference in the matter which are within the domestic jurisdiction of member state. Question number 48. Qualifications for a member of United Nations is it must be supported by a Western power, it must be peace loving state, it must be a peace loving state and able to carry out the obligations of the Charter of the United Nations. Option D is none of the above. Option C is right, it must be a peace loving state and able to carry out the obligation of the Charter of the United Nations. Question number 49. A state can be admitted to United Nations when it first recommended by a majority of 7 members including all 5 permanent members of Security Council and later approved by 2/3 majority of General Assembly. Option B, when it is recommended by all 5 permanent members of the Security Council and later approved by 2/3 majority of General Assembly. Option C, when it is recommended by all 5 permanent members of the Security Council. Option D is none of the above. Option B is right. B is right. It is recommended by all five permanent members of the Security Council and later approved by two-third majority of the General Assembly. Question number 50, which is last. Under Article 5 of the United Charter, a member can be suspended from right to membership, privileges of membership, special duties entrusted by United Nations, rights and privileges of the members. D is right. So thank you guys. Thank